Good afternoon, everyone. ICS Yogesh Kumar Jha welcome you all to 50th session of EEE 4.0 Master Knowledge Series of ICSI on topic Significant Beneficial Ownership, Compliances and Implication. Significant beneficial ownership is the concept of identifying and disclosure from individual or entities that hold a substantial level of control, influence over a company or legal entity. The genesis of the concept of significant beneficial ownership under the Indian law can be traced to Financial Action Task Force, FATF, recommendation on issues pertaining to transparency and beneficial ownership of legal persons and arrangement. Considering the recommendation from FATF, the Companies Act 2013 encapsulate specific provision for the identification and disclosing the significant beneficial owners who have substantial control over the company. The law governing significant beneficial ownership was codified under the Section 90 of the Act with the Companies SBO Rule 2018. Section 90 of the Act read with the SBO Rule prescribe twin tests to determine the significant beneficial ownership of a reporting company, Indian company. The first is objective test, which determine an individual status basis their percentage shareholding at the reporting Indian company level and majority holding through the ownership chain. The second is subjective test, that is determining whether the person has right to exercise or actually exercising significant influence or control in any manner other than merely through directly holding. Further, given the FATF recommendation and the legislative intent, it is imperative to narrow the regulatory net of who are significant beneficial owners and move away from significant beneficial owners to ultimate beneficial owner. Every company shall designate a person who shall be responsible for furnishing and extending the corporation for providing information to registrar or any authorized officer with respect to beneficial interest in the share of a company. This is a deeming provision, and therefore there is a responsibility on the company secretary to be aware about the group structure as well as different beneficial interest in the shares of the company with the same intent today session scheduled on the topic significant beneficial ownership, compliances and implications. Today, to deliberate on the topic of the session and understand the nuances of significant beneficial ownership and compliances thereof, we have with us CS Kuldeep Ruchandani, practicing company secretary. It is my profound privilege to read his brief profile in the front of all our learned members. He is a fellow member of Institute of Company Secretaries of India and a gold medalist in postgraduate diploma in financial management. He has also been associated with ICSI Pune chapter in various roles. As a practicing company secretary, he specializes in legal, commercial areas covering corporate, commercial laws, regulatory compliances, and litigations. His work areas include FEMA laws, corporate and security laws, merger and amalgamation, corporate restructuring, corporate and secretarial procedures, corporate governance, foreign trade policy, and IP rights. It is our proud privilege to have him speaker for today's session and get benefited from his words and wisdom in critical area of SBO. With his brief profile, we welcome him at the 50th session of EEE 4.0 Master Knowledge Series and hope to have enthusiastic learning. Additionally, I would like to remind our dear professional colleague that application for ICSI National Award for Excellence in Corporate Governance have been open for the year 2024. We solicit your application under 24th ICSI National Award for Excellence in Corporate Governance, 9th ICSI CSR Excellence Award, 3rd ICSI Business Responsibility and Sustainability Award, and the ICSI Lifetime Achievement Award. The last date to apply in all categories is 40th August 2024. And for further information, please visit website of ICSI. We also like to inform that the Institute of Company Secretaries of India, through its Section 8 company, the Institute of Governance Professionals of India, is excited to announce the launch of ICSI Board Mentorship Program. This initiative is designed specifically to enhance the skills of board members, senior management, KMP. We warmly invite you and your board member to participate in comprehensive program which will place in UT from 12th to 14th September. The registrations are on first come basis and limited seats. For further information, we request you to please visit the website of ICSI. Participants individual questions to take up at the end of the sessions. Now, I request distinguished speaker to share his knowledge on the topic given today, which is significant beneficial ownership, compliances, and implications. Welcome, sir. Please, over to you, sir.
Yep. Thank you. Thank you so much, Yogesh. So good afternoon, my esteemed colleagues. Firstly, I would like to extend my heartfelt thanks to ICSI for providing this platform and this opportunity. And it's an honor to speak with you all today on a topic that's at the forefront of corporate governance, which is significant beneficial ownership. You know, in an era where transparency is not just a regulatory requirement, but a cornerstone of a good governance, understanding who truly owns and controls our companies is more critical than ever. But identifying SBOs isn't just a matter of ticking boxes on a compliance checklist, and I'm sure all of you will vouch for this. Rather, it's about safeguarding the integrity of the business environment. Now imagine navigating a ship through treacherous waters. The visible structures like the deck and sails are clear to everyone. However, it's what's beneath the surface, the unseen parts of the ship that often determine its stability and direction. In the corporate world, if I have to compare, the visible entities are akin to shareholders and the directors, while the unseen forces are the significant beneficial owners, those who hold substantial influence behind the scenes. It's like, I feel like it's like peeling the layers of an onion, where after each layer, it reveals more about the underlying structure and the true influences behind a corporate identity. As we all know, nowadays the corporate world is under increasing scrutiny. Regulators are more vigilant, and we have seen a lot of adjudication orders also being issued under Section 90. I think it's like we are playing a chess game where every move of a corporate is scrutinized. And recently we also saw that, e-adjudication rules have been notified, which are going to be in effect from September. Understanding the rules, understanding the recent rulings, can mean the difference between what is compliance and what are the significant consequences if there is going to be a contravention. So today we will explore the concept of SBO, which goes beyond mere identifying the shareholders to uncover the true influences. But we will also delve into certain recent adjudication orders that have set new precedents and have made it mandatory for the corporates to reassess their process of identifying the SBOs. The recent orders have also clarified certain regulatory expectations, how the SBOs are being identified by the regulator. Yogesh, in this opening remark, rightly mentioned about from where this compliance or this requirement is coming, about the FATF recommendations. So, yes, in June 2018, India kicked off the compliance of identifying or requiring the corporates to identify the SBOs. However, since its inception, neither the regulator nor the companies have been able to take a sigh of relief here when it comes to implementing this directive, this requirement of identifying an SBO for their company. There have been several amendments followed by, now recently in the last year in November, earlier in 2022, then in November 23, the requirement of identifying SBO has also been extended to LLPs. So we are going to discuss about that as well today. Last year, we also observed that ROC has been sending advisories, notices to the companies, seeking clarification on why they have not or whether they have identified the SBOs or not. So this is what today's agenda is going to be. Let me put up my screen. Yogesh, just confirm me if it's visible to you as well.
I will confirm. Yes, it is visible.
So let's just talk a little bit about, Yogesh has already mentioned about the origin of these rules. It's come from the recommendations to an FATF to its member countries, where India is also one of the member countries. The recommendation was to make suitable changes in the legislations to help entities, corporates find out who are the individuals who are the ultimate significant beneficial shareholders in the company. In the year 2016, CLC, the Company Law Committee, also noted that there are prevailing complex structures. There are chain of corporate vehicles which are used to hide the real owners behind the transaction. And the main purpose of introducing this concept was to prevent the misuse of corporate vehicles for the purpose of evading taxes. Money laundering has been an evil, and many countries are trying their best to fight out this menace. So that's also one of the objective why these recommendations were brought in, to prevent the laundering of money for corrupt and illegal purposes, and including the terrorist activities that has been a concern worldwide. Now in India, the legal framework governing the SBO, is it visible? To me, it said it's paused. I don't know.
No, sir, it is visible.
In India, as I said, in 2018 was to be specific, 13th of June 2018, when this SBO kicked off in India, where government amended Section 90, which provides today the scheme how the SBO identification, what are the compliances applicable to the person who is an SBO, what are the compliances applicable to the company, what are the actions which a company needs to take if they are unable to identify an SBO. And through rules, they have also defined who is an SBO, how to identify an SBO. So Section 90, read with the company's significant beneficial rules 2018, plus the recent orders, today define the framework for a company to help them comply with this requirement. In 2003, November 9th, 2003, the MC has also notified LLP SBO rules, which today lays down the rules and compliances which are required to be adhered by the LLPs, because this compliance is applicable to the body corporates in India. So be it company, be it LLP. Though in 2022, in Feb 22, it was introduced for LLPs, but the rules, how the compliance has to be implemented in LLP, was notified in November 23 only. So we are going to discuss a little bit about that as well. As regards applicability of SBO, this compliance is concerned, this applies to all companies, whether they are listed, unlisted, small, big. It applies to each and every company in India, except the exemptions which have been provided in Rule 10 of the LLP rules, of the SBO rules, and also one-person company or Section 8 companies which are limited by guarantee, are out of the purview of these rules. If the reporting company has a shareholder who is not an individual person, which means if it's a company or a body corporate or a partnership or a trust or an HUF, is a direct shareholder, then SBO rules apply to such company. We will discuss more about this in the further slides. Now, as regards beneficial ownership is concerned, under Companies Act, there are two types of beneficial ownership which are being defined. And Section 89 and Section 90 are the relevant provisions which deal with this. Now, beneficial owner means any person who holds the beneficial interest in the shares. So if there is a shareholder and the beneficial interest of those shares does not belong to that person but to a different person, which means the registered owner of a share is a different person and the beneficial owner of a share is a different person. For that particular situation, we have a compliance prescribed under Section 89, where the registered owner as well as the beneficial owner needs to give their declaration in the forms which are prescribed in MGT 4.5. So MGT 4 is the form which the registered owner gives. MGT 5 is the form which the beneficial owner gives, and MGT 6 is the form which the company files with the registrar of companies. The requirement of this compliance are defined in Section 89. Now, talking about beneficial ownership, FATF has defined the beneficial owner as the natural persons who ultimately owns or controls. So they have emphasized it has to be a natural person who ultimately owns or controls. A little while ago, I was talking about that in Companies Act, there are two types of beneficial ownership. One as a beneficial owner, and the second is a significant beneficial owner. Now, beneficial owner can be a body corporate, need not be a natural person, but a significant beneficial owner for which the provisions are defined in Section 90 has to be mandatorily a natural person and individual. So there can be a situation where a company has a registered owner, which is different from a beneficial owner, and they have complied with the requirements of Section 89, wherein the declarations have been given and filed. But the beneficial owner of those shares is a body corporate. In such a scenario, initially, there used to be discussions around this, that if a company has complied with Section 89, whether they need to comply with Section 90. So in the example which I shared just now, if the beneficial owner of a share is a body corporate and not an individual, not a natural person, then Section 90 will also have to be complied by a company. But in case where the registered or the beneficial owner of the shares is a natural person and the registered owner is someone else, and company has complied with Section 89, in such situation, the question arises, whether do I still need to comply with Section 90? The answer is no. We are going to discuss this in more detail in the upcoming slides. Now, when we are talking about beneficial ownership, there is another term which comes into discussion again and again, and that is beneficial interest. So we will discuss about that as well. So this we discussed, the declaration of beneficial owner. So the member who does not hold beneficial interest. So Section 89 subsection 1 says if a member who does not hold beneficial interest should file a declaration. So if I'm a registered owner and the beneficial interest in the shares, so the term uses beneficial interest, then I have to file a declaration. Now, if you see, can there be a scenario where there is an individual holding the shares in his own name, and the beneficial interest in those shares is also belonging to another individual. So we will discuss, there has been a very interesting case in Jan 24, and we will discuss this there, where ROCs in a company, in their adjudication order, in a company where all the shareholders are individuals holding the shares directly, have still went on to apply section 90 and 89 and levied penalty on the company. A very, very interesting case. We'll discuss that for sure. So 89.1 talks about the requirement on a member to give declaration who does not hold beneficial interest. Similarly, the one who holds the beneficial interest also needs to give a declaration. And after the two declarations have been received by the company needs to file a declaration, the form with the ROC in MGT 6. 89.3 also requires that if there is any change in the beneficial interest, that also needs to be declared to the company within 30 days. Now, as we were discussing, the section 89 as well as 90 talks about beneficial interest. So let's understand what does beneficial interest in shares mean. So beneficial interest in a share, the definition is given in section 89 subsection 10. And there it's very beautifully said that it is related to section 89 as well as 90. So to me, it is a starting point of section 90, where 89.10 says beneficial interest in a share includes, so it's an inclusive definition, which says beneficial interest in a share includes directly or indirectly through any contract, arrangement, or otherwise, if a person is holding the right, whether alone or together with any other person. What kind of rights or entitlement? 1. Exercise or cause to be exercised any or all of the rights attached to such shares. So as a shareholder, if I'm holding a share, if directly or indirectly, whether through a contract or arrangement or otherwise, if a person has a right to exercise or cause to be exercised any of the rights which are attached to such a share. So if I'm a shareholder, what are the rights do I get? Right to vote, right to receive dividend, right to participate in rights issue, right to get notices for AGM. So all these are the rights which are attached to such shares. Second, receive or participate in any dividend or other distribution in respect of such shares. So 89.10 beneficial interest talks about two different rights. One, a right or entitlement to exercise any or all rights attached to such shares. And second, to participate in the dividend or any other distribution in respect of such shares. And this includes not only the direct interest, it also includes the indirect interest. Now let's go to section 90 and see how section 90 requires the SBO and the company to comply. So what are the compliances? So let's discuss. So this is what the scheme of section 90 is. In 90 subsection 1, I've just reproduced the exact section, the entire section here. It starts with every individual. So in 89, there can be any person who is not an individual holding the beneficial interest, and 89 compliances kicks in. In section 90, it starts with every individual, which means for section 90, the SBO can be only an individual. It cannot be any other person. Now, which individual? An individual who is acting alone or together or through or one more persons or trusts, including the trusts and persons residents outside India, holds beneficial interests. So beneficial interest we just discussed, right to participate in the right attached to the shares, the voting rights, the dividend rights, holds beneficial interest of not less than 25% or such other percentage as may be prescribed. So section 90 initially prescribed for not less than 25% as a threshold, but then or such other percentage as may be prescribed. And we know in the rules, the threshold which has been prescribed is not less than 10%. So for the purpose of identification, we have to forget, for the purpose of section 90 and the compliance thereunder, we have to forget that threshold of 25%. We have to just focus on the 10% because section 90 says or such other percentage as may be prescribed. So because such other percentage has already been prescribed, the 25%, not less than 25%, that threshold is of no relevance as on date. So any individual who acting alone or together or through one or more persons or trusts, including those which are resident outside India, holds a beneficial interest of not less than 10% in the shares of a company or the right to exercise or the actual exercising of significant influence or control. The control has been defined in section 2, subsection 27. Significant influence has been defined in the rules, which we will discuss in some time. So if there is an individual who either acting alone or together or through or one or more persons or trust, including those registered outside India, if he holds a beneficial interest of not less than 10% in the shares of a company, or he has a right. So the words in the shares of a company or, which means there are two tests to identify an SBO. One, as Yogesh also rightly said in the opening remarks, one is the subjective test, which talks about identifying the indirect shareholding related to the shareholding in the company. The second, which is an subjective test, which talks about significant influence or control, right to exercise or actual exercising. So even if someone has only a right to exercise and he has not actually exercised the significant influence or a control, he can still be considered as an SBO. Now, if there is such individual who acting alone or together through one or more persons or trust, including the trust which are a person and persons resident outside India, holds a beneficial interest of not less than 10%, or he has a right to exercise or is actually exercising significant influence or control, then he shall make a declaration to the company specifying the nature of his interest and such other particulars within such period of acquisition of beneficial interest or rights and any change thereof, as it has been prescribed in the rules, which is he has to give a declaration in Ben 1 to the company. 90 subsection 2 and 3 requires a company to maintain the register and keep it open for inspection. 90 subsection 4 requires the company to file the return of SBO, which is Ben 2. Register has to be maintained in form Ben 3. Now 94A was introduced in the year 2019, which requires a company to take necessary steps to identify an individual who is an SBO. And if we read section 4A and 5 gives a very specific direction, or there is a specific requirement in subsection 5, which says company to issue notice in Ben 4 to those person whom company knows or has a reasonable cause to believe that this particular person is an SBO, or this particular individual has a knowledge who is the SBO, or he has been an SBO in the preceding 3 financial years. So 5 talks about giving notice in Ben 4. 4A is a continuous obligation on a company to take necessary steps to identify an individual who is an SBO. And we'll see 4A and 5, because in the penal provisions in the adjudication order, there has been reference. So some adjudication order talks about non-compliance or contravention under 94A as well as 5. Some talks only about 4A. So we will see that as well in the further slides. Now, if this is what section 90 is, so 90 subsection 6, 7, and 8 talks about application, after the notice is served, within 6 talks about the responsibility of a person to whom the notice is served to respond to the notice in Ben 4. If no satisfactory response is received in 97, the company has to make an application to the tribunal. 98 also deals with the proceedings before the tribunal. And then there are penal provisions in the section 90. So this is what the scheme of section 90 is. Now this, along with the section 90, we also have to refer to the SBO rules. And in the SBO rules, there are explanations. So the word terminology SBO has been defined in the rules also, in the rule 2H, which we will be discussing in some time. But before we go to that, there are 2 interesting explanations in the rule, in the definition of SBO. Explanation 1 and explanation 2. Explanation 1 says, if an individual does not hold any right or entitlement indirectly in the shares, in the voting rights, or a distributable dividend or other distribution, he shall not be considered to be a significant beneficial owner. Which means this explanation clearly establishes that for an individual to be an SBO, it is mandatory for him to hold any right or entitlement indirectly. So if there is an individual who is a direct shareholder, he will not be considered as an SBO. For an individual to be considered as an SBO, the right or entitlement in the shares, in the voting rights, or distributable dividend has to be an indirect right. Now, explanation 2 goes on to further explain what shall be treated as holding the right directly. So if one says if there is an indirect right or entitlement, then only the individual can be considered an SBO. Explanation 2 explains what will be treated as holding the right or entitlement directly. Explanation 2 says an individual shall be considered to hold a right or an entitlement directly in the reporting company if he satisfies any of the 2 criteria. So there are 2 criteria which have been defined. The first criteria is if the shares in the reporting company representing such right or entitlement in shares, in voting rights, or in distributable dividend are held in the name of an individual. So if he is a direct shareholder, the shares are directly held in his name, will be considered as a direct holding. Second, which is very interesting, the individual holds or acquires a beneficial interest in the shares of a reporting company under subsection 2 of section 89, which talks about where the registered owner is someone else and the beneficial owner is someone else, and the registered owner and the beneficial owner has to give declaration MGT4 and MGT5, and company has to file MGT6. So if there is an individual who has the beneficial interest in the shares, or who has acquired the beneficial interest in the shares, and he has complied with the requirement of section 89 subsection 2 by giving a declaration to a company that I am an individual holding beneficial interest in the shares, and company has filed the return with ROC, then such individual shall be treated as holding the right or entitlement directly in the reporting company. Now imagine a scenario. Let me give you an example. So there is a company, reporting company X Limited, and in that X Limited, there are two shareholders. One, Mr. A, who holds 80% shares. Now, because Mr. A as an individual is holding the shares directly, the first part of the second explanation 2 says if the shares are held in the individual name, then he will be treated as holding the shares directly. And because he is holding the shares directly, he cannot be considered as an SBO. The second shareholder in the company, let's say, is a partnership firm, wherein Mr. X and Mr. Y, both partners, are holding the shares jointly, representing the beneficial ownership of a partnership firm. And they have given a declaration to the company. So partnership firm has given a declaration that they are the beneficial owner of those 20% shares, which are held by Mr. X and Y. And Mr. X and Y have also given a declaration to the company that they are the registered owners, but the beneficial interest of these shares lies with partnership firm. In this case, because the declaration under section 89(2) has been filed, the shares are held by which entity? The partnership firm, through Mr. X and Y. Because if the beneficial interest declaration has been filed, who is the beneficial owner here? It's not an individual. The beneficial owner is a partnership firm. And therefore, whether individual holds the beneficial interest, the answer is no. It's the firm which holds the beneficial interest. Let's take another example where in the same example, 80% shares are by an individual, 20% shares are held by a company on behalf of another individual. And that individual, Mr. X, has filed MGT5, company has filed MGT4, and MGT6 has been filed. In the second example, because the beneficial interest has been declared and Mr. X is the beneficial owner of shares that has been reported under section 89, because of the explanation 2 and because of the declarations given, he will be treated as holding the shares directly. And therefore, even if in the company, the registered shareholder for 20% shares is a company, but a beneficial ownership declaration has already been reported that the shares are held for Mr. X, Mr. X will be treated as holding the shares directly and will not be considered as an SBO. So if we read explanation 1 and explanation 2 together, one requires an individual to hold the right or entitlement indirectly. Explanation 2 defines what will be treated as holding the shares directly. And if an individual is holding the shares directly, he shall not be considered to be an SBO unless he also holds the right or entitlement indirectly. So there can be a scenario where an individual is holding the shares directly, holding the right and entitlement directly, as well as he is holding the right and entitlement indirectly. So because in the second scenario, he is holding the right and entitlement in shares indirectly also, in such a scenario, he can be considered to be an SBO, provided the threshold defined in the Rule 2H and Section 90 of not less than 10% are complied, or the significant influence or control is established. Yogesh, if there are any questions, you can feel free to interrupt me in between.
Right now, I have not received any questions. Once I will be receiving, definitely I will be putting on.
Perfect. So till now we are clear that there are two types of beneficial ownership. One under 89, where a person other than individual can also be a beneficial owner, and 89 has to be complied. Section 90 requires an individual who is holding the right or entitlement indirectly of not less than 10%, or who has a significant influence or control, has to give a declaration to the company. And what will be considered as indirect, what will be considered as a direct holding, we have also discussed. And an individual will not be treated as an SBO unless he holds any right or entitlement indirectly. Let's move further. So this is an illustration where Mr. A has already given a declaration. I explained another example, but this is also an illustration where there is a reporting company in which P Limited is holding 10%, and P Limited 80% of these shares or the stake is with Mr. A. Now, Mr. A has already given a declaration under 89 for the shares which he is holding in the reporting company through P. Hence, his shareholding through P Limited will be treated as direct holding, and hence no SBO declaration will be required. In a scenario where he has not given a declaration under Section 89, then definitely Section 90 and the rule has to be applied, and the SBO will have to be identified. Because here he has already given a declaration, and pursuant to the explanation 2 and read with explanation 1, he will be treated as a direct holder, and therefore no SBO declaration is required. The another example, there is a reporting company in which Mr. B holds 50% shares. There is another trust who is holding 10%, where Mr. A is a trustee. Now, since the holding, Mr. A and also Mr. A, being a trustee of a trust, has already given a declaration under Section 89 for that shares. Since the holding as beneficiary is not regarded as indirect holding, and there is no other indirect holding, there is no case for declaration. Because there is a declaration filed under Section 89, both the shareholders will be treated as direct shareholder, and therefore no SBO declaration is required. Mr. A also holds directly 40%, but that fact is irrelevant, because the question of SBO will arise only for the 10% shares which are held in the name of trust. But because Mr. A has already given a declaration for those also, for that 10% also he will be treated as a direct holding, and therefore there is no requirement of filing an SBO declaration. Now let's go to what are the explanations given in explanation 3 to Rule 2H. And it's a very, very interesting definition, I would say. Just a second. Yeah. Now, significant beneficial owner in relation to a reporting company. Now, this is the gist of what Rule 2H defines. Significant beneficial owner in relation to a reporting company means an individual acting alone or together, or through one or more persons or trusts, and he possesses one or more of the following rights or entitlements in the reporting company. What kind of rights or entitlement? One, holds indirectly or together with directly, right? So in the earlier slide we were discussing, there can be a scenario where an individual holds the shares directly as well as indirectly. If he is only holding the shares directly, there is no requirement of an SBO. But if he is holding the shares indirectly and together with directly, if he is breaching this threshold, then an SBO declaration will be required and he will be considered as an SBO. But together with indirect and direct holding, if he does not breaches the shareholding threshold, with the threshold of 10% or more of shares, 10% or more of voting rights, or 10% or more of the distributable dividend or other distribution. And then the fourth, which is the subjective test, which says has a right to exercise or actually exercise significant influence or control. So this we have already discussed. Rule 2H gives two tests, one subjective test and objective test. Objective test talks about threshold of not less than 10%. Subjective text talks about right to exercise or actually exercising of significant influence or control. But the starting of this particular definition is interesting and needs to be focused upon. An individual acting alone or together. Now, there can be a scenario. I'll share a few illustrations in a while. Let's say there is a company X Limited, in which, let's say 6% of the shares are held by Y Limited. 7% of the shares are held by Z Limited. X Limited is a reporting company. Y Limited holds 6% shares. Z Limited holds 7% shares. No declaration under Section 89 has been filed. But both these Y Limited and Z Limited are 100% owned by Mr. A, which is an individual. So X Limited, one of the shareholder, Y Limited, holds less than 10%, let's say 6%. Another body corporate, Z Limited, holds 7% shares, again less than 10%. But both these shareholders, Y Limited and Z Limited, are 100% owned by Mr. A. In such a scenario, will it be possible to conclude, and because the definition starts with an individual acting alone or together, or through one or more persons or trust. Now, can I say Mr. A, who is an individual, through Y Limited and through Z Limited, holds indirectly more than 10% shares in the reporting company? So Y Limited holds 6%, Z Limited holds 7%, both added together comes to 13%, which is more than 10%. If we go to the explanation talks about majority stake, which we will discuss. But here the interesting observation of the definition is an individual who is acting alone or together or through one or more persons. And I will be tempted to take a view that Mr. A will be considered as an SBO. And in my opinion, that's a right view, because the definition says through one or more persons, if an individual holds more than 10% of the shares indirectly in the reporting company, then he will be treated as an SBO. Now the words, so the first test talks about 10% threshold in shares, in voting rights and distributable dividend or other distribution. The fourth condition is right to exercise or actually exercise significant influence or control. Now, what do you mean by significant influence or control? Now, significant influence has been defined in the explanation in the rules only. whereas control has been defined in section 2, subsection 27. So let's dwell on these two terminologies also. Very, very crucial. Significant influence means the power to participate directly or indirectly in the financial and operative policy decisions of the reporting company, but is in not control or joint control of those policies. Which means an individual, if he has a power to participate directly or indirectly in the financial and operating policy decisions of the company, but he's not in control or joint control of those policies, it will be said that he has a significant influence. As regards control is concerned, it is defined in 227, and it talks about control shall include. Again, it's an inclusive definition. So the scope of this definition is very wide. And this definition is also very interesting because it talks about two types of control, de jure as well as de facto. The first part of the definition talks about de jure control, whereas the second part of definition talks about de facto control. De jure means given by law. So given by law, control shall include the right to appoint the majority of the directors or to control the management or policy decisions. So if any individual has a right to appoint the majority of the directors or to control the management or policy decisions exercisable by a person or persons acting individually or in concert, directly or indirectly, including by virtue of shareholding or management rights or shareholders agreement. So this part of the definition talks about de facto control, where the rights are getting arised because of some agreement, some contract. It's not a control which has been given by law. It is a control which is coming by virtue of the shareholding rights or an agreement, including by virtue of their shareholding or management rights or shareholders agreement or voting agreements or in any other manner. So very wide definition. So if there is any individual who has a right to appoint majority of the directors or to control management or policy decisions exercisable by a person, by a company or persons, different companies acting individually or in concert, directly, indirectly, including by virtue of their shareholding or management rights. So it's a very wide definition, and therefore when we see the orders which have been passed, there has been a lot of insistence on the terms significant influencer control, and in many orders ROC has come to a conclusion where companies have sticked to the first test, the objective test of threshold of 10%. They have missed to apply the subjective test of control and significant influence. Now, in the definition given in Rule 2H, there is an explanation 3 which talks about how to identify an SBO if the member of a reporting company is body corporate, HUF, partnership firm, or a trust. And in explanation, and the pooled investment vehicle also. And in explanation 4, those pooled investments vehicle which are not belonging to a FATF compliant country, what will be the rules for identification of an SBO if there is a member who is a pooled investment vehicle from such country? Those criteria are given in explanation 4. Now let's discuss one by one. An individual shall be considered to hold a right or entitlement indirectly in the reporting company, where member of a reporting company, first case let's take of a body corporate. Here the body corporate excludes LLP, excludes LLP. So LLP is not covered under the body corporate category. It is covered under the category of partnership entity. So if there is a company, reporting company, and where a member of a reporting company is a body corporate, whether it is registered in India or abroad, there are two tests. If that body corporate has an individual who holds a majority stake in that member. So X Limited is a reporting company. There is another company which is registered, let's say BINC, which is registered in US. And BINC has a shareholder who is holding majority stake. Then such individual will be treated as an SBO. Second test, there can be a scenario, and there are multiple examples where there are layers of companies in between before we reach to the ultimate owners. In such a scenario, individual who holds majority stake in the ultimate holding company of that member. So reporting company, we have to go a layer up. There's a body corporate shareholder. Let's find out who are the shareholders in that body corporate. And let's for example, in that body corporate who is a member, there is another body corporate which is a shareholder. Then we check who are the shareholders of that body corporate. And by going up in the layers in the hierarchy, if we reach to an ultimate holding company, then we see who are the individuals who are holding majority stake in the ultimate holding company. And if there is no individual who holds majority stake in the company, then by virtue of applying the objective tests, we can come to a conclusion that there is no SBO. But the second test remains to be applied, which is there any individual who is exercising significant influence or control? Because in that test, there is no relevance of the threshold of 10% or more. Second, let's say if the member of a reporting company is an HUF, then whoever is the Karta of HUF, the individual who is a Karta of HUF will be treated as a SBO. Now here, let's take another example similar to what we discussed. Let's say there is a company ABC Limited in which one HUF holds 8% shares. HUF is holding 8%, which is less than the threshold of 10%. And then there is Mr. P, who is not the Karta of HUF, but one of the co-partners of the HUF, who is directly holding the shares in the company, reporting company. And let's say he holds 5% shares directly. HUF, if there is an HUF which is a shareholder or member of the company, whoever is the individual will who is the Karta will be treated as an HBO. So if HUF is holding 8% shares, then Karta of HUF will be treated as the SBO. But because the threshold of 10% is not getting breached, the shareholding is only 8%. But we have another shareholder in the company, direct shareholder, which is Mr. P, which is not a Karta, who is a co-partner. But he is holding 5% shares. Now, members of an HUF are considered as relatives as per the definition of relatives under Companies Act. And because we saw the definition of an SBO under Rule 2H, which starts with an individual acting alone or together, or through or one more persons, there can be a scenario where a conclusion can be drawn that Mr. P, which is holding 5% shares in the direct capacity, if we can establish that he is acting together with the HUF, then the Karta of that HUF will be treated as an SBO. because of the indirect shareholding act, which is together with another direct shareholder, which is who is a co-partner. But for that, we will have to establish whether both Mr. P, who is a co-partner, as well as HUF are acting together. Third is partnership entity. So if the member of a reporting company is a partnership company, partnership entity, through itself or through a partner. If the shares are held through itself or a partner. In such a case, individual, if that partnership firm, all the partners are individual, then the individual who is a partner of that partnership firm will be treated as an SBO. But let's say in that partnership firm, there is no individual is a partner, or there is one of the body corporate also, which is a partner. Then the individual who holds majority stake in the body corporate, which is a partner of a partnership entity, will be treated as an SBO. So let's take an example. There is a company X Limited in which one of the shareholder is a partnership firm holding 20%. And in that partnership firm, there are two partners, Mr. A, 50% partner, XYZ Limited, which is a company, which is a partner in the partnership firm. Then in that XYZ Limited, whoever is the individual holding majority stake will also be treated as an SBO along with another individual partner of that partnership entity, which is a shareholder in the reporting company. Third, holds majority stake in the ultimate holding company of the body corporate, which is a partner of the partnership entity. So again, here there is a possibility that partnership firm is a member of a reporting company. In that partnership firm, there is another body corporate, which is a partner. And in that body corporate, the shareholder is another body corporate. So as I said, we have to go up in the layers to find out who is the individual holding the majority stake in the ultimate holding company. But while evaluating the layers, if we come to a conclusion or we observe there is no ultimate holding company. For example, in a body corporate, there are 5 different shareholders, which are a company, and all the 5 companies are holding 20% each. We cannot say that there is a ultimate holding company unless there is a significant influence or a control. So holding subsidiary relationship also, there is a possibility of a company become a subsidiary by virtue of exercising a control. So in such scenario, if there is no ultimate holding company, then obviously the question of reaching to an individual who is an SBO will not be possible. Again, I'm saying, reiterating, this is by virtue of the objective test. Subjective test is totally independent of the thresholds defined. Next is the trust. Now, trust, 3 types of trust has been defined in the explanation. If it's a discretionary trust, then whoever is the trustee will be treated as an SBO. Now, what if that trustee is a body corporate? Because it is possible for a trust to have a trustee which is a body corporate. In such a scenario, the explanation does not give any clarity, but in my opinion, whoever is the individual holding majority stake in that body corporate will be treated or shall be treated as an SBO. Second is, if there is a specific trust, then whoever is the beneficiary, and in case of a revocable trust, the author or settler will be treated as an SBO. Last category defined is pooled investment vehicle, which are in the FATF compliant countries and where the regulator of such country is a member of IOSCO, which is an international organization for securities and commission, somewhat similar to what we have SEBI in our country. In such a case, if the PIV is a shareholder of a reporting company, then the individual in relation to such PIV, who is general partner or who is an investment manager or who is a CEO, where the investment manager of such company is a body corporate, such individual shall be treated as a SBO. And in respect to pooled investment vehicle, there is also an adjudication order. Let's see if the time permits, we will discuss this. Of Lexier, the company named Lexier, there is a adjudication order where the shares are held through pooled investment vehicle. A very interesting case again. Now, the explanation 4. So this is what explanation 3 talks about. Scenarios where member of a reporting company is either body corporate, Hindu undivided family, partnership firm, trust, or pooled investment vehicle. Those pooled investment vehicles which are in the countries which are FATF compliant. But there can be a shareholder who is a pooled investment vehicle, not from a jurisdiction which is FATF compliant. For that, explanation 4 says where the member of a reporting company is a pooled investment vehicle or an entity controlled by a pooled investment vehicle based in a jurisdiction which is not a member of FATF, and the regulator of that state is not a member of IOSCO, the provisions of clause 1, clause 2, or clause 3, or clause 4 of explanation 3, as the case may be, shall apply, which means body corporate, Hindu undivided family, partnership firm, and trust. So we will not look at the fifth category, fifth clause of general partner, investment manager, or CEO. We will look at if it's a body corporate, then individual holding the majority stake. If it's a partnership entity, then individual who is a partner or individual holding the majority stake in the body corporate of such partner. So clause 1, 2, 3, 4 talks about member of a reporting company, it's a body corporate, HUF, partnership firm, and trust. So explanation 4 says if a pooled investment vehicle or any entity which is controlled by a pooled investment vehicle is based in a jurisdiction which is not FATF compliant, then we will not look at this fifth column. We will focus on first 4 columns to identify the SBO. Now we have also been given an explanation for what will be treated as acting together. So there is an explanation given in explanation 5, in explanation 6 also we will discuss. These explanations are a part of Rule 2H of SBO. So explanation 5 says if any individual or individuals acting through any person or trust act with a common intent or a purpose of exercising any rights or entitlements or exercising control or significant influence over a reporting company pursuant to an agreement or understanding, whether formal or informal, such individual or individuals acting through any person or trust, as the case may be, shall be deemed to be acting together. So again, a very wide explanation. First of all, it talks about individual or individuals, whether acting through a person or acting alone, or so they are acting with a common intent or purpose. Now, how to establish there is a common intent or a purpose? Again, this depends on the facts of the case and the cases which we are going to discuss. The ROC has gone to such a great extent to verify whether there is common intent or a purpose. Common intent and purpose for what? To exercise the rights and entitlement or to exercise control or significant influence over a reporting company. That can be by way of an agreement, even if there is no agreement, because in some of the cases where companies have given their replies or responses, they have again and again insisted that there is no underlying agreement. And ROC has concluded that agreement or understanding is not a requirement. It can be formal, it can be informal. So if there is no written agreement, we cannot say that the persons are not acting together. Now, in the case of body corporate, in the case of partnership entity, there is a usage of word majority stake. Now, what does majority stake means? Majority stake means holding more than one half, more than 50% of the equity share capital in the body corporate, or the voting rights in the body corporate, or having the right to receive or participate in more than 50% of the distributable dividend or any other distribution by the body corp. And the shares also has been defined in the explanation 6, which means shares will include equity shares, compulsorily convertible preference shares, compulsorily convertible debentures, as well as GDRs, global depository receipts. Now, when we look at these, the explanation of shares, few questions which comes to the mind is, when, let's say, because this includes CCDs, how we are going to identify whether the threshold of 10% is going to be breached, is getting breached or not? And what will be the stand to be taken? What stand to take if the preference shares are not compulsorily convertible preference shares, but optionally convertible preference shares or non-convertible preference shares? What stand to take in such a scenarios? Because the explanation 6 only covers these 4 categories: equity shares, CCPS, CCDs, and GDRs. Now, in CCPS and CCDs, we can also calculate by arriving the stake held on a fully diluted basis, which means considering that CCPS and CCDs which are held have been converted, let's see what is the percentage we are arriving at and whether it is crossing 10% or not. But when we are filing the BEN 1 or the declaration is given, because the CCDs does not have any voting rights today, in the BEN 1, can I mention the BEN 1 by virtue of voting rights? In my opinion, it won't be possible. We will have to select beneficial ownership is by virtue of shares. And whenever these CCDs gets converted into shares, we will have to again file, because now the beneficial interest has changed along with shares. Now the voting rights have also crossed beyond 10%. So these are some of the anomalies which revolves around different type of securities which the companies issue for raising the capital. And I'm sure there will be a lot of other difficulties in the different type of instruments which the companies nowadays issue. How to calculate that threshold of 10% is going to be a challenge in few scenarios. Now, this is about identifying an SBO, and I have dedicated a separate slide. What are the steps one can take, a company can take? Let me look at the time. Okay, let's hurry. Now, what are the compliances applicable? So, in case there is an SBO, what are the responsibilities this section or the law casts on an SBO? The responsibilities of an SBO includes, he has to first of all give a declaration in BEN 1, specifying the nature of his interest and other particulars. What are the timelines? He has to give the declaration within 30 days of acquiring such beneficial ownership. And if there is any change which is happening after giving initial BEN 1, then also he is required to give a separate declaration in BEN 1. Whenever there is a change, even the slightest of change, he will have to give a declaration to the reporting company in BEN 1. The timeline for both after acquiring as well as for any change remains 30 days. Now, what are the responsibilities on the company? The responsibilities of the reporting company are: first, they have to maintain the register in Form Ben 3. Second, that register has to be kept open for inspection by the members. Next is reporting. After receipt of declaration in Ben 1, they have to file the return in Ben 2 with the registrar, again within a period of 30 days from the date of receipt of such declaration. Now, imagine a scenario where company had received an advisory notice last year, and then they started this exercise of identifying an SBO first. And they identified, okay, there is an SBO and a compliance was missed. I have observed there are few cases where the companies have taken a Ben 1 with a declaration date being 2018 when this requirement had come in, which means there was no contravention on the part of the beneficial owner, SBO. He gave the declaration. But the non-compliance was on the part of a company that they failed to file Ben 2 within a period of 30 days. In my opinion, we should not, whatever is the fact must be reported, because if by any means it comes to the surface that the declaration was taken antedated after receipt of advisory notices, then obviously the regulator is going to catch hold of the SBO also as a non-compliant or the one who is not complied with the requirement, and he may levy the penalty on that SBO as well. Next is, if the company feels, the reporting company believes or has a reasonable cause to believe that so and so person is an SBO, then they have to serve him a notice in Ben 4. Or if they know that this particular person will have a knowledge that who is an SBO or can help us identify an SBO, then to such person also a company is required to give Ben 4. And last, they also have to give Ben 4 notice to an SBO who has been an SBO in 3 preceding financial years, but currently is not a direct shareholder. Now, if after serving the Ben 4, if the company has not received any response, or the person has given the information but a company is not satisfactory, then the reporting company has to make an application to the tribunal. There is another responsibility casted on the reporting company as per Rule 2A of the SBO rules, where it says every reporting company shall in all cases where its member, so if the member of a reporting company who is not an individual holds not less than 10% of its shares, voting rights, or right to participate or receive dividend or other distributable dividend or other distribution payable in the year, to such member also a company is required to give notice in Ben 4. Now, statutory responsibility is, as per this rule, if there is a member who is not an individual and is holding more than 10% of the shares or voting rights or right to participate in the dividend or other distribution, then to such company I have to serve Ben 4. This is a statutory requirement. But there can be a scenario where a member who is not an individual holds less than 10%, but the individual who is behind such member is holding the shares in the reporting company through other entities as well, or he has direct shareholding also, In such a scenario, all put together, that 10% limit can get breached. So in my opinion, and that's a very practical advice I'm giving, that even if there is a member who is not holding the shares less than 10%, we must go and exercise, apply all the rules to see if there is an individual who is holding majority stake and whether that individual has interest through other persons in the same reporting company, or whether that person has any direct shareholding. To give you an example of this, let's go to an example. So this is a case study where there is a reporting company in which 20% of the shares are held by H Limited, which means a reporting company has a member which is not an individual. And that H Limited is owned by three different entities, which is one BINC hold 33%, X Limited holds 1/3, PQR INC also holds 1/3. And all these three entities are owned by one individual, which is Mr. A, 100% owned by Mr. A. Now, it would not be incorrect if I disregard that layer of BINC, X Limited and PQR and conclude that Mr. A is an HBO. Because again, the section wordings are an individual who acting alone or together or through one or more persons. So here, through one or more persons, he is holding indirectly more than 10%. Now, the SBO rules also give exemptions to certain companies where they need not carry out this exercise of identifying an SBO. So we'll quickly go through that. So IEPF, central government or state government, holding company, holding reporting company. So if there is a holding reporting company, let me show you an example. Yeah. So H3 is a subsidiary of H2. H2 is a subsidiary of H1. And Mr. A holds 51% in H1. Mr. A has already been declared as an SBO for H2, which is the holding reporting company for H3. For H3, I don't need to do the exercise of finding an SBO because SBO of my holding company will be an SBO for H3 also. But they still need to declare the details of holding reporting company in BEN2. So H3, when they have to file their BEN2, they will have to file it, and in the form they will have to select the category reporting of holding reporting company, which is H2 in the present example. Reporting company or body corporate owned or controlled by the government, SEBI registered vehicles such as mutual funds, REITs, InvITs, AIFs, investment vehicles which are regulated by RBI, IRDA, pension fund and other regulatory authority are also exempt from the applicability of these rules. We'll quickly go through this case study. I think we have discussed this. So I'm going to skip it. Yeah. So holding is in this example, if we see the reporting company has only one body corporate, and that's what I was saying, that even if the shareholding of a non-individual member is less than 10%, we must still go and apply the rules to identify who is the individual holding the majority stake in the reporting member of reporting company or the ultimate holding company. In this example, if we see Mr. A is holding majority stake in the ultimate holding company, and therefore by virtue of applying the rules, 8% held by H1 in reporting company will be treated as indirect holding of Mr. A. But because Mr. A also holds 5% as a direct shareholding in the reporting company, and in the definition it says together with direct holding if it is going beyond 10%. So 8 plus 5 goes beyond 10, and Mr. A will have to give declaration, SBO declaration in Ben 1. So therefore, I was saying that don't just stop if the shareholding of a non-individual member in a company is less than 8%. If there is any other individual, there can be another example which we discussed here. The same individual is holding the indirect interest through different entities. And therefore, it is a very, very imperative for us to apply the rules, even if the shareholding of non-individual member is less than 10%. This we have discussed. So what are the concluding steps? This is again my understanding of what needs to be done by a company. First step is identify the reporting company for which we need to ascertain who is the SBO and check who are the direct shareholders. Second, check indirect shareholding in the reporting company. If there are any non-individual members holding the shares, if the answer is yes, then we go to next step. If the answer is no, then all the shareholders are direct shareholders and there is no requirement of an SBO. Identifying an SBO. Because the explanation one says for an SBO, an indirect holding is necessary. But again, I'm saying, let's not forget the subjective test of a significant influencer control. There can be all the individuals direct shareholders. Still, there will be an SBO who has a significant influence and control. Check percentage of shares held by indirect entities and apply the rules of identification under rule explanation 3. Clause 1, 2, 3, 4, 5, depending on who is the entity, body, corporate, trust, partnership, firm. Apply the rules and see what are the percentages we are getting, who is the individual behind these layers. Step 4 is once you have reached to the individual, by applying the rules, aggregate with the direct and indirect shareholding. So if there is an individual we have reached to and he has a direct shareholding also, then aggregate direct and indirect and see if he's going beyond 10%. If it is less than 10%, but we have reached to 2-3 individuals, see if there is any facts or circumstances which indicate that they may be acting together. And I'm saying it's easier said than done. It's going to be very, very challenging. But yeah, for the sake of identification, that's another process. And we'll discuss in some time what are the steps a regulator has taken to establish this common intent or a purpose. Next is identify if there is any individual we reach to who holds 10% direct, indirect put together. If you reach to a conclusion, so if there is no SBO, we don't have to stop there. If you reach to a conclusion that there is no SBO, or if you fail to reach to a conclusion, in both the scenario, if you have decided or if you are, identified that there is no SBO, or you have been unable to identify who is the SBO, I would say still issue Ben 4 to the immediate non-individual shareholders as per Rule 2A. Because in the adjudication order, it has been pointed out again and again by the regulator. What steps did the company take? In your reply, a company has said that there is no SBO. And the regulator is still asking, have you issued Ben 4? So, in my opinion, it will be a good compliance or a good governance that if to verify your stand that there is no SBO, let's still issue a Ben 4 to the immediate non-individual shareholders and let's comply to that requirement also. And I would say law requires anyways to issue Ben 4 to immediate non-individual shareholders who are holding more than 10%. I would insist to do it even if it is less than 10%. The penalties are there. So for SBO, if he fails to give a declaration, then he will be liable to a penalty of 50,000 and INR 1,000 per day, subject to maximum of 2 lakhs. For a company, if they fail to maintain the register, fail to file Ben 2, fail to issue notice under 94A. Interestingly, here they mention only 94A, whereas Ben 4 issuance has been clearly defined. The requirement of issuing Ben 4 is there in 90 subsection 5. Or the company has denied inspection of register, then company shall be liable to a penalty of 1 lakh and 500 per day, subject to a maximum penalty of 5 lakhs. And every other officer in default will be liable to a penalty of 25,000 and 200 per day for continuing default, subject to maximum of INR 1 lakh. And if there is false declaration or wrong declarations given, then section 447 also gets applicable. So this is about the companies. Yogesh, if there are any questions, I would love to take here. If not, then
yes, sir. We have received some important questions, sir. So with your due permission, we would be taking up the questions now.
Sure.
So the first questions we have received with respect to the recent substitution of Ben2 form. So the question is in respect of the SBO who had ceased to be SBO in the company much before the introduction of the latest form Ben2. Do we need to file the Ben2 in the latest format? Or this new form Ben2 needs to be filed only in the respect of those SBO who cease to be SBO after introduction of the said latest form?
So, in my opinion, if we see the section, every change has to be notified in Ben 1 first and then has to be notified in Ben 2 by the company. So, if the Ben 1 for the change was received earlier, but Ben 2 was not filed. So, if I understood the question correctly, after introduction of new form, if you have not filed Ben 2, it is advisable to file the Ben 2 even if it was not filed earlier. Even if it's in the new format, I think it's immaterial. The declaration received has to be filed for every change which has been there in the beneficial ownership.
It means that if declaration has been received, then we have to file the Ben2.
Yes.
So the second question is, in case of the Indian company, which is a wholly owned subsidiary of a foreign company, say H Limited, and H Limited is a wholly owned subsidiary of a listed foreign company. Is Indian company required to comply with the provision of Section 90? In this case, is it difficult to determine the individual here?
Yeah. So as I said again and again, in case of a listed company, you may not be able to identify an SBO by applying the objective tests, but very soon we will discuss few of the orders and the famous LinkedIn matter where the ROC has applied the subjective test and found Mr. Nadella as an SBO. So I would say if we go through the order, it's a very interesting order. We'll discuss the facts and we'll dwell upon it. But in my opinion, after these recent orders, it has become very, very imperative for a company to reassess their process of identification and not just stop if the ultimate holding company in the chain is a listed entity. Right. Now, I'm not going to comment upon whether that the order will hold legally valid in the courts of law and whether LinkedIn is going to challenge it or not. I'm not aware of it. I think as of now, what has been established by that order is what we must introspect on and reassess our processes. And I'm sure these type of matters will come up, in due course of time. And because of these orders, because whenever the courts will intervene in such matters, we will have more clarity on the entire concept of SBO and how these rules needs to be applied to identify an SBO. Yeah.
So next question is with reference to LLP. In case of a LLP, whether Form 4D or Ben2 to be filed when another LLP is a partner in which an individual holds 50% interest.
So LLP we will discuss in some time. So I suggest we take this question after I have explained the LLP concept, SBO and LLP. Anything related to SBO in a company, we can address it now.
So the next question is, if a company is a public limited company, being a 50-50 joint venture, where no one is holding more than 50%, so will both the two promoters, shareholder, each have to give a declaration of SBO to the reporting entity of their holding?
If there are facts indicating that they are acting together with the common intent or a purpose, I would say yes. Again, as I said earlier, it's very difficult to establish, but we will have to look at the facts of the matter, how the matters are being decided in the board meetings, what kind of control those two individuals are exercising, and can we come to a conclusion that they are acting together.
So the next question is, do I need to file MGT6 in case where the shareholder of the company is one individual and one company, where the company holds the beneficial interest in the individual shares, but the company is owned by individual 100%?
So if I've understood correctly, it's a scenario where a company is holding the shares as a registered owner, but the beneficial owner of those shares which are held by a company is with an individual.
Individual, yes, it is the correct
scenario. MGT 4, 5 and 6, these will have to be complied. 89 will have to be complied.
So then another question is, in our company structure, the ultimate holding company is a trust with 4 trustees. To accurately identify the SBO for compliance's purpose, could you please clarify who would be considered the SBO in this context? Specifically, should we focus on the beneficiaries of the trust or the trustees or another party? Additionally, what criteria should we use to determine the SBO if multiple beneficiaries or trustees have varying degree of control or benefit from the trust?
So in case of trust, I think we'll need more details to answer this query, particularly what type of trusts are there, because the explanation 3 talks about only 3 type of trust. Discretionary trust. If it's a discretionary trust, the trustees will be treated as an SBO. If those are individuals, if the trustees are not individuals but a body corporate, then the majority stakeholder of that body corporate who is a trustee of a discretionary trust will be treated as an SBO. If it's a specific trust, then the beneficiaries. If it is a revocable trust, then the author or settler. So we need more details here to, give a concrete answer. Maybe the author of this question can reach out separately and we can have more one-on-one discussion on this.
Sure. So another question is, in case of shares held in the name of minor through his father and natural guardian, will Section 89 be applicable? So it is a case in which a minor holds shares through his father or natural guardian. Will the Section 89 will be applicable?
So beneficial ownership of those shares is with the minor, and the registered owner is different. Is a different.
Yes. Yeah.
And Section 89 is primarily about that. If the registered owner is a different person and a beneficial owner is a different person, then the compliance is under Section 89 needs to be done.
Compliant. Sir, can a member send his proxy to inspect the register ban 3?
The Section 90 subsection 3 talks about, the register has to be kept open for inspection by any member.
Yes.
It does not talk about a proxy of a member. And therefore, in my opinion, it should not be allowed.
So the next question is, if a director is holding directly 55% and indirectly holds 30%, should we require to file ban 2?
Yes.
For the indirect shareholding, I think, sir, it is required.
Direct and indirect both needs to be clubbed together. And if it goes beyond 10%, SBO declaration is required and ban 2 filing and all other compliances will be applicable.
Sir, the next question is declaration under MGT 4, MGT 5 given voluntary by a shareholder or company need to take any action for identifying the same?
I would say it's a voluntary declaration, but we
Yes, it
also
is.
look at the facts because, for example, I'll give you a scenario where a company was incorporated and in the subscription, it was mentioned clearly that an individual is holding the shares in the capacity of nominee of another company. Then you have already, disclosed that the subscription to the memorandum is happening in the capacity of a nominee. And there have been cases where a company had declared a shareholder as a nominee of another person in their financial statements also, but had not filed MGT 456. Right. So if you have in any of the disclosures already disclosed that the beneficial owner and the registered owners are different, and you have not complied MGT 456, then I would say it's a non-compliance. Even though it's a voluntary disclosure, voluntary declaration, but in the disclosures already reported, you have already established the registered and beneficial ownership is in two different hands, then compliance is mandatory. In such a scenario, I would say if I am a compliance officer or a company secretary, my job will be to reach out to those shareholders and the beneficial owner, get the declarations and file in MGT6. And again, this was also one of the observation in, I think, in the one of the ROC order where in the financials it was already declared as a nominee shareholder holding on behalf of another registered holder, but no filing under M89 was done, and therefore penalty was levied under Section 89 also.
Sir, another question is, if an individual become SBO prior to the effective date of SBO rules, say in 2015, what will be the date of acquiring beneficial interest in Form Bentu? Will it be date in 2015 or effective date of SBO rule, that is 14 June 2018?
So I think transitional provisions were there. We were given 90 days to comply with the reportings, and that period has already, in my opinion, lapsed. We are already in 2024, rules came in 2018. But as regards date of acquisition of beneficial interest is concerned, in my opinion, that remains the date on which I had actually acquired.
So another question is, ABC Limited is a wholly owned subsidiary company of XYZ, and XYZ and A and B holders 25% shares each. Is bent to apply in these A and B holding as indirect in ABC company?
Can you please repeat this again?
Sir, ABC Limited,
on subsidiary of XYZ.
So I'm repeating the question, sir. ABC Limited is a wholly owned subsidiary of XYZ company, and XYZ hold by A and B, which both are holding 25% of shares. In this case, the participant is asking whether the band 2 need to be applied to the A and B as a holding indirect in ABC.
So, in my opinion, XYZ, we have been, given the facts that A and B are holding 25% each. We don't know who holds the remaining percent. But let's say if it is by some other person, if in the member of a reporting company, so ABC is a reporting company here, member of a reporting company, which is XYZ here, there is no majority individual who is holding majority stake, which is there is no one holding more than one half of the shares or voting rights or right to participate in dividends. In such a case, again, by virtue of the objective tests, there is no SBO, but significant influence and control test needs to be applied.
So another question is, considering recent order passed and position taken by the ROC, whether that all global CEOs will be considered as SBO by default?
I would say I'll park this question till I discuss the order.
Sure. So where a company has no SBO, does it mean that there is no individual controlling the company?
No, we cannot say that, because, as I said, once you say there is no SBO, which means have you applied all the tests, right?
Depends on the tests.
And because you are saying there is no SBO, I am presuming that you have applied both the test and hence come to a conclusion. And interestingly, when the SBO as a concept was introduced under Companies Act, which later on got amended in 2018, in the erstwhile rules, there was a specific provision that in case a company is unable to identify an SBO, then the relevant natural persons occupying the senior managerial positions will be treated as can be treated as an SBO, right? Unfortunately, or I don't know what's the reason, there is no such provision in the rules and the section which is prevalent now. But I think the similar concept is also there in the FATF recommendations, that in case there is no SBO identified by applying the rules, then the relevant natural persons who is occupying the senior managerial position can be treated as an SBO. So similar concept is there in the FATF recommendations also. But again, in the present scenario, I would say there are cases, there are orders where such stand has already been taken and people are already questioning about that orders. But again, if I read the rule 2H and the explanation, in my opinion, explanations are clarifying a position. It does not clearly define that, okay, this is how it has to be interpreted. Explanations are there only to support the interpretation and clarify how an SBO needs to be identified. But primarily, what is the definition of SBO in Rule 2H, which talks about whether acting alone or together, through or one or more persons, having the right or entitlement of not less than 10% in the shares, voting rights, and dividend, or right to exercise or actually exercising significant influence or control. This is a main definition. What is given in explanation of, in case of a member who is a body corporate, how to identify an SBO, all these explanations are there just to facilitate the interpretation. Those cannot be said there as a conclusive test of identifying an SBO, and that's what coming out very clearly after you read the orders of the ROC. And I think we should discuss those orders also. So if there are no more questions, we'll take those cases, the orders. Yes.
So we have left with 3 more questions, sir.
Yeah, please.
Sir, is Section 90 applicable for equity share only or also covered preference share and other kind of shares?
This is already given in the explanation 6, that the shares includes, the share means CCPS, CCDs and GDRs.
So the next question is to provide prove the significant influence control. What document we need to take for Benfo?
So I would say it's not a very easy question to answer and depends on facts. But if you read the orders which have come out, the ROC has gone on to check the LinkedIn pages, the websites of the companies, the minutes of the board meetings, the policies of the companies, the trademark applications filed by the companies in various jurisdictions, the domain name of the email ID of a director is owned by which company. So this is what the extent of inspection, or I would say, has been there from the ROC's end. And after the findings of all these verifications done, inspections done, they have come to a conclusion, okay, he is an SBO. For example, the case of Metec, let me talk a little bit about it. In Metec, all the shareholders are individual shareholders. So there is no shareholder in the company in the financial year 21-22 who is an indirect shareholder. There is no company, there is no non-individual shareholder. Still, ROC has concluded that there is a requirement to give SBO declaration, because what these shareholders have done, they have tried to mask the identity of true owners of the company. And they have established the linkage between an Indian company and a Chinese global company. And one of the method, or one of the finding in their observation has been, they checked the mail ID of a director, major shareholder in the company, and then checked who is the domain owner, and they found that the domain owner of that domain is a Chinese entity. So this is what the level of extent of verification has been. I'm not the person to comment whether this is right or not, wrong. But when the question comes, what kind of documents or facts we should look into to determine whether there is significant influence or control, I think there is no clear-cut answer to this question. It will depend on how the company is functioning. There are cases where the provisions of articles of associations also has been looked into. Bank account operating authority also has been considered. So that's what happened in the case of LinkedIn, where bank account operating authority was also, questioned. So yeah, so I don't know how to answer this, but the extent is very wide, I would say.
So it's totally depend on the company and
I
which
would say
environment they are.
easier to say, but very difficult to apply. And consider I am an insider to an organization and I have to comply this. There is a limit to which I will go, right? The regulator is free to ask and come to any conclusion anyways. But from a very, very, independent perspective, if I have to say, being an insider, it's going to be very difficult to establish or say, conclude that yes, Mr. Nadilla, you are an SBO in this company. Yes.
So next question is, if the ultimate holding company is a listed company, then how we identify this?
I think we have discussed this. This is a repeat question. In the listed company, again, I said the objective test you may not be able to reach to any individual, but subjective test remains to be applied. And again, it's easier said than done. How to
So we have a last question. If HUF is a shareholder, then MGT4 and MGT5 is required to be filed.
So if Karta is the shareholder holding the shares on behalf of an HUF, then yes. If he is holding in the individual capacity, the answer is no.
So we have covered all the questions from the participants. So now to conclude the session.
So let me take the orders and a little bit on the LLP aspect as well.
Sure.
So if we see the definition or the LLP rules, they are almost similar to what is there for companies. But interestingly, the concept of LLP and a concept of company is very different. There is no concept of directors' share capital in LLP. There is a concept of contribution. To that extent, the necessary changes in the rules has been done. But more or less, if you will read the rules, they are akin to what the rules for companies are there. But interestingly, if you see in the explanation, they talk about individuals shall be considered to be an SBO where the partners of reporting LLP is HUF, partnership entity, trust. But if you read the section A5 of LLP Act, whether that allows you to have an HUF who is a partner in an LLP, the answer is no. Then what's the relevance of this explanation? Again, that's a very, very gray area to me, and will be of no relevance in such a case, because you cannot have an HUF who is a partner in an LLP. So these questions are there, and I think with time the rules will get amended or evolved. but more or less the responsibilities on the SBO, responsibilities on the LLP, it's the same. The form numbers are also same. Instead of Ben 1, it's LLP Ben 1, LLP Ben 2. The timelines are same. And again, the transitional provisions of the rules also have lapsed. So as regards exemptions is concerned, again, reporting LLP, if it is held by the contribution in the LLP is held by government, state government, local authority, reporting LLP or a body corporate owned by government, SEBI registered vehicles such as mutual funds. So these exemptions which are there in companies also, the exemptions are there for LLP also. Now let's talk about the recent adjudication orders. So this is what the LinkedIn the shareholding structure is. The LinkedIn India is 100% owned by LinkedIn Ireland Unlimited Company, and LinkedIn Technology Unlimited is a nominee. LinkedIn Ireland is again the holding company is Microsoft Ireland Research, and Microsoft Ireland Research is owned by Microsoft, which is a listed entity. Now, facts are Microsoft Corporation USA is the ultimate holding company if we see, because the ultimate holding company in the chain for LinkedIn India is Microsoft. And Microsoft Corporation USA has been regularly filing the statements of changes in beneficial ownership. And the ROC has given a link for accessing those statements filed on SEC also, and it's a public document anyways. LinkedIn India, whereas in this case has not submitted any Ben 2, and they have sticked to their response that there is no individual holding majority stake in the Microsoft Corporation. So if we see the explanation 3, majority individual holding majority stake in the ultimate holding company will be treated as an SBO. And therefore they said that because there is no individual holding majority stake, there is no SBO. But then ROC has identified SBOs based on 3 factors. 1, the nature of relationship between LinkedIn India and its holding companies. The nature of reporting channels, who is reporting to whom, who is controlling whom, and the financial control exercised over LinkedIn India, which means they have gone beyond this objective test and have tried to establish whether there is an SBO by applying the subjective test. Few more facts which has helped to ROC, or on the basis of which they have come to a conclusion, is LinkedIn India listed LinkedIn USA as its holding company in the financial statements, even though LinkedIn USA has no direct shareholding in LinkedIn India. So if we see, there is no LinkedIn USA mentioned in this table. But still the company continued to mention that LinkedIn USA is a holding company. And therefore ROC presumed that the LinkedIn USA is not a holding company primarily by way of shareholding, but because of the control exercise. Both the entities are subsidiaries of Microsoft. So ROC determined that LinkedIn USA could only be considered the holding if it controls the LinkedIn India's board of directors. So that's what, because in the financial statements, I think there was one question also that, and I mentioned in one of my answers that if you have already reported something in the financial statements, then ROC is going to look into that and interpret it accordingly. And that's what happened in the LinkedIn India's case. Then ROC concluded that Mr. Ryan Rolansky, the CEO of LinkedIn USA, has the authority to exercise control over LinkedIn India's board because he is the CEO. LinkedIn USA is a is a holding company because that has been disclosed. Ryan Rolansky, the CEO of LinkedIn USA, the holding company, has authority to exercise control. And because Ryan Rolansky reports to Satya Nadella, ROC examined the filings with US SEC and found that Rolansky is a part of Microsoft senior leadership and reports to Satya Nadella, the CEO of Microsoft Corporation. And as a result, ROC concluded that Nadella is also liable to be disclosed as an SBO in LinkedIn India. So this is what the famous case is, the facts, and it's a very detailed order, some 68 or 70 page order. It is very, very interesting, and I would urge everyone to go and read this order, because there are a lot of findings which have been explained by the ROC. Very interesting. The second case I would love to discuss is of Samsung Display Noida Limited, which is again ROC Uttar Pradesh. So we have Samsung Display Noida Private Limited, is an Indian reporting company owned by 100% owned by Samsung Display Company Limited, which is SDC Korea. For SDC Korea, we have a holding company, Samsung Electronics. So this is a holding company. This is immediate holding. This is the holding of this company. And if we see Samsung Electronics, there is no major shareholder. We have Samsung Life holding 8.6, family members of Lee Jae-yong 21%, Samsung CNT 5%, and other minority shareholders are holding all put together 64. But in this also, there is no one holding more than 50%. So there is no majority shareholder in the Samsung ultimate holding company. Samsung Life is owned by 19% is with Samsung CNT Corporation. 19% is by Lee Jae-yong, who also have 35% in Samsung CNT. So this is what the structure is. It's given in the order also. So if you see the tests given in the explanation 3, there is no individual holding majority stake in Samsung Electronics. So the facts are, SDNPL, the wholly owned subsidiary, did not file e-form Ben2 state indicating non-compliance with the declaration of beneficial ownership. Company in its, so this was a notice issued. The company in its response stated that it is fully owned by SDC Korea, which is 84% owned by SDC Samsung Electronics Korea, and 15% by Samsung SDI. Both of these companies are listed on Korean Stock Exchange. They contended that since no individual holds a majority stake, no individual qualifies as an SBO. In view of ROC, the company has failed to consider indirect holdings where shares are held through one or more entities rather than directly. The ability of certain persons to exert significant influence or control over the management and policies, whether directly or indirectly. They went and checked what was the declaration given, under the RBI KYC norms, and there the company had declared their CEO as the UBO. So, the question was, what kind of documents do I need to check? So ROC has went on to check the UBO declaration submitted with the banks also. And once you have established in a declaration that there is a UBO, in another law, you are saying there is no SBO. So in view of ROC, since the reporting company is a wholly owned subsidiary of SOC Korea and SEC Korea as an ultimate parent company, it was bound by the law of land at the first instance to serve Ben 4. And this was, I was insisting that this was what ROC questioned, that did you serve Ben 4 to the immediate holding company, irrespective of the fact whether there is an SBO or not? You did your exercise, you concluded there is no SBO, but did you serve Ben 4? And obviously the company had not. The reporting company, therefore ROC concluded, the reporting company has failed to discharge its obligations. Then Mr. Lee Jae-yong's appointment as executive chairman of SEC Korea, despite micro shares, suggests proxy control vested through remote mechanism. And therefore the default under 90 was established and the company was levied penalty. Third case is very interesting, and I don't know whether, I don't subscribe to the way the indirect shareholding has been calculated in this. Here also, if you see, the ultimate holding company is either financial services And in that, there is again no majority shareholder as such. If you see this order, in the order, ROC has insisted who owns Philippines Wireless INC and company had failed to respond with the information. So they have not provided, and therefore ROC has, concluded based on the information what was available. Interestingly, what they have done, they have calculated the indirect holding, and it's given in the order. And what they have done proportionate calculation. So if either PWI 74.99% is with IDER Infotech, and IDER Infotech 58% is by IDER Financial Services, and which 48.79 is Ramasena. So what they have done, 48.79 multiplied by 58.21 multiplied by 74.99. And that's how they have calculated that Ramasena holds indirectly 21.29. And in my opinion, this is beyond what is given in the rules. So whether this will hold good or not, only the time will tell. But in my opinion, this is not given anywhere in the rules. This is what I was, talking about Metec Electronics Private Limited, where the shareholders are all individual. But in the financial statements, the company had reported certain countries, certain entities as held under common control, which are all Chinese companies. So what was the action taken by ROC? ROC acted against the subject company. Investigation details which the ROC has verified is the reviewed trademark registry records. They also questioned who had filed the trademark application. The company secretary was also called for hearing. The company secretary in employment as well as was a consultant in the trademark registration process was also questioned. Scrutinized email IDs used, which revealed that domain is of a Chinese company. Assessed objections and statements filed. Examined the balance sheets, and then they reached to a conclusion that there is a common nexus which is getting established between the Indian entity and a Chinese entity. And therefore, they concluded that company and its current shareholders have failed to declare beneficial interest, and the individual shareholders who are holding the shares are trying to mask the original beneficial owners. And therefore, they have identified Mr. Jiangping Hu, who is the operationals director, as an SBO and asked the company to comply with Section 90. So this is what has been the analysis of few of the recent orders, and there are many. I would say I would request at least to go through these orders. Very, very interesting orders, and the way ROC has come to a conclusion of identifying an SBO and levying a penalty is very, very interesting. And therefore, after this, it's very, very important, for us to reassess what needs to be done in terms of identifying the SBO. Yeah. So as we wrap up the session, it's clear that the landscape of governance and compliance is continually evolving. And the complexities of identifying SBO coupled with the insights which we have gained from the recent orders, it highlights the critical role we all play in fostering transparency within the organizations. And I reiterate, our work is not just about ticking boxes on a compliance checklist. It's also about upholding the integrity and trustworthiness of the sector, corporate sector. So thank you all for your active participations and very, very insightful questions. All the questions were very, very insightful. And I would be more than happy if there is any question which I have not been able to address. Please reach out to me and I would do my best to, share my response. It has been a pleasure to share this space with you all, with my fellow professionals. Let's continue to uphold the highest standards in our work and contribute positively to the corporate governance landscape and be a proud member and the representative of our institute. I look forward that our paths cross again in future. Look forward to having, any opportunity in future also to interact. Thank you so much, Yogesh, for being a wonderful moderator. If there are any questions, we can take. Otherwise, I leave it to you.
Sir, right now we don't have any questions. Sir, thank you so much for sharing a wonderful knowledge on the topic. I hope the participants are enlightened on the topic. I also like to thank the participants who actively participated in sharing the important questions. The recorded version of the session is available on the YouTube for the participants' comfortable access. Thank you. Thanks a lot.
Thank you.